All right, we're going to go over estate planning, which is basically passing down your wealth at the event of your death or incapacitation. It's not just for rich people, just so you know. Estate planning is simply creating a plan for your assets, tangible or intangible, so we'll talk a little bit about what that means. In the event of your death or incapacitation, if something happens to your mental health or you're super sick or whatever it is, you're going to need someone to kind of control that when you pass. So first of all, we're going to take an account of inventory, so everything that you have in your home or the things that you want to pass on. You're going to start with the tangible items here, and that is what your land that you own, your home or homes that you own, your collectibles, baseball cards, etc., your automobiles, electronics, etc. So anything that you have that you can hold, that you can touch, you're going to start taking an account. Write that down. There's a lot of great websites out there like Vanguard and Fidelity. They offer a couple of really cool spreadsheets for you to write that down with and to save it somewhere on a cloud or on a hard drive, somewhere safe that you can have. It's good for insurance, but it's also good for passing it down to your children or whichever. Next, we have intangibles, which is your life insurance, retirement, investments, like stocks, bonds, annuities, etc., and your bank accounts. What happens to those in the event that you're incapacitated or not alive anymore? Then, once you take an account of everything that you have, you're going to go ahead and choose your beneficiaries. And that's really just someone who will benefit from a trust or a will or your insurance policy. If you're at a bank, sometimes they'll ask you to add beneficiaries to your account. So in the event of your death, it won't go to probate court. Some things still might go to probate, but what you're trying to avoid is all the money that you're going to spend at probate, all the taxes and all the headache that it takes that happens when in the event of your death, because you're going to if and when you die. Your loved ones are going to have to make decisions on what to do, and sometimes that gets really tough for your loved ones, especially if it could create a division in your family, and you don't want that to happen. So you're going to choose your beneficiaries wisely, usually your kids or your grandkids, etc., your spouse. Those are the people that you're going to choose, and make sure that those are people that you want to benefit from something happening to you. Next, you're going to look at a couple of documents that you're going to need. One is a will and testament and a trust, and the other is a power of attorney. Here's what a will and testament is. So basically, it dictates what happens to you, to your assets, but only when you die. That's the big difference between a will and testament and a trust. Is a will and testament only takes into effect when you die. It also has to go through probate court. Here you go, and it only addresses assets titled to the individual, not joint. So it'll be you have a will and testament for yourself, and you should have an individual one for your spouse as well. Because it does not include joint accounts. All right. So what you'll have to do is have they'll basically in an account in let's say a bank or whatever, it'll split it 50-50 in probate. But you can tell in your will and testament what your 50% where your 50% is going each. So that's the best way to do it. It does require probate court to acknowledge and distribute the funds. So it will have to go to probate, but probate then doesn't make the decision. Your will and testament makes the decision on where things go. If you don't have a will and testament, probate, the court decides on their best judgment who gets what and when and how. So this is the whole idea, is to avoid the government telling you where your money is going to go in the event of your passing. You can assign, will and testaments can assign guardianship to your surviving children. It is a powerful document. It does allow for assigning guardianship. So in your will and testament, trusts don't do that, but your will and testament can do that. So you do want to look this up. You can find will and testament templates on like LegalZoom.com and or other places. Find a professional and make sure that you get this done correctly. Next, we have a trust. Now, this is a legal binding document that will actually have, it's kind of its own entity. You have three different types. You have the revocable trust, which allows the person to basically do whatever they want at any moment. The person who opens it, the trustee or the guarantor, what they'll be able to do is they can change, dissolve it, do whatever they want during the lifetime of the trust while you're living. The irrevocable trust does not allow you to do that, but there are some tax benefits to it. That's why some people believe that the irrevocable trust is better. Um, and the next one is the testamentary, which is basically means that your will say something like, if you write this in your will and testament, you can say, in the event of my death, I would like to open up a trust by this name, and these assets go into the trust. That's a testamentary trust, which basically means the person who opens it has passed away, but they have stated in the will that the trust is to be open. Those are the three different trusts. There are some other small things that go into that that you should probably get with a professional to figure out the best setting for or the best written trust and will for your situation. So the next thing is trust can be funded while you're living, whereas a will and testament only takes an effect when you die. The trust can be funded while you're living, which means you can fund it with any kind of asset you want. You can put land in its name. You can put money, bank accounts, whatever it is. You can put it in the trust's name, and the trust will spell out what to do with every penny. In the event that you're incapacitated mentally, where you have no control over it anymore. And you also can appoint what's called trustees and co-trustees who will take care of that trust. All right, that trust account. Trusts have the following people that are involved. You have the grantor, which is the funder of the account, the person who funds it. Then you have the trustee or trustees. Those are the operators of the account. Those are the ones that control the stuff that's within it. So usually that's hopefully that's you, and maybe you have a lawyer who could be a co-trustee, or someone you trust to be a co-trustee, like your spouse, that can operate the accounts. And then you have the beneficiaries, the receivers of the account. So in the event that something happens, the beneficiaries are the ones who receive the money if any event that something happens to the trustees. Assets then must be written over to the trust name. For example, when I was working at the bank, I've seen lots of trusts, and most trusts say something like this. This is what they'll be titled: the Revocable Living Trust of the blank family, and I put mine in there, the Flynn family, and it's just a name, a legal binding name, that when things are written, for example, if you want to write a check to that account, you must write it to the Revocable Living Trust of the Flynn family. It actually becomes a legal name. Next, you have the durable power of attorney, and this is kind of the catch-all. It's able to act on a person will be able to act on your behalf anytime, including, and if it's written this way, putting things into your trust. So let's say you've created a trust, but you forgot to put some things in there. This is a good way to catch all that kind of stuff. Because if you were to die and have forgotten to get that, or maybe you came into some money while you were dead. Let's say you won the lottery, but you haven't received the payments yet. The power of attorney can do that for you and put it into trust. So make sure that it's somebody that you trust wholeheartedly. And in fact, a power of attorney can do things with your assets, even if you're out of town. They basically have full control over things, that whatever it is that you have written in your power of attorney. So this is a great thing to have outside of your trust. I would have all three of these documents set up in a way that will help you manage your money in the event of your death. Because what we're trying to do is we're trying to avoid the government, again, taking your money just because you died. That's not how this should work. You earned it, you worked hard for it, and you wanted to pass it down to the next generation of your family, and you can do that. Some trusts actually say, or in will and testament say that in the event of someone's death, they pass it on to a charity or a church. It doesn't matter. It's your money, but you want to be able to say where it goes, not the government, right? That's the goal. So a power of attorney is a good way to do a kind of a catch-all for things you may have forgotten to add into your trust, or assets you may obtain after your death or incapacitation. Power of attorney is great for that. Next, after you found those things and you set them up, you're going to have to take into account some tax law that govern your estate. So the three big ones are gift tax and the estate tax, which usually right now they go hand in hand. As of 2019, they are basically laws in common. And then there's inheritance tax, which are very rare. I think only about 6 states have those. As far as I know, In 2019, only 6 states actually have an inheritance tax now, so they're very rare. And you may find yourself in one of those states, so you have to take that into account. So first of all, let's look at the gift tax. The gift tax is this: it's a 40% tax on gifts that you give over $15,000 as of 2019 per person per year while you're living. Okay, so what you want to do? Let's pretend that you have some money, and you want to start giving this money away to your child or your grandchildren or whatever. You can give every year up to $15,000 per person per year. And anything above that, it's going to go into your lifetime exemption. So let's say that you went over about $1 million. So you gave $1,015,000 one year. Then your lifetime exemption will drop down to 10.4 million, because you only have 11.4 million of an exemption all your whole life, right? The thing is, not many people have actually, they actually say 2 out of every 1,000 estate plans will actually give out more than this $11.4 million in terms of taxes, right? So it's very rare if you even hit that mark. It'd be nice if that comes to play, and you're going to have to change some things and find some pretty creative accounts. But so gift tax is a good way to get rid of your money before the estate comes and kicks it in, right? Now we have the federal estate tax, which is also 40%, which shares the gift tax exemption of 11.4. This happens only when you die. So once all total assets are calculated after your death and is transferred, that number will go against the 11.4 million exemption and then taxed on anything exceeding it. So if you've already cut in about $5 million in here, or $6 million, then you only have $5 million left. Then if you total all of your assets and it goes above $5 million, well, you're going to be taxed 40% on the excess above that 11.4 and that gift tax 11.4, because they share that exemption. All right. I hope that's as clear as mud. Tax law is very unclear, of course. Tax accountants have a tough time, I know. But these are the three. These are the three you're going to have to be aware of when planning for your estate. All right. The next, of course, right, is your state inheritance tax. Some states have it. Only 6 states, actually: Iowa, Kentucky, Maryland, Nebraska, New Jersey, and Pennsylvania. So if you live in any one of those 6 states, you may be subject to anywhere between a 1 and 18% state inheritance tax, and each one of those states have their own lifetime exemption amount. So you may not hit that lifetime exemption, or you may hit that lifetime exemption. It just depends. In my mind, as a conservative economist, I believe that these are bogus. A tax on your stuff just because you die makes no sense whatsoever. The money was already taxed when you first earned it. There's no reason to tax it again just because of your death. The whole idea is you're passing down money to your generation that you earned, right? That's the idea. Lastly, always update your information. Keep it updated. You need to change things as life happens in your life. You're going to have kids, or you may not have kids. You may adopt kids, or you may not adopt kids. You may move. Something catastrophic could happen to you. Job changes, change of your income, deaths in the family, etc. There's a lot of things that happen in life that God helps try to prepare you for, but you also want to be smart to help yourself prepare as well. So make sure that you keep all your information, your beneficiaries, your POA, your power of attorneys, your trust. Make sure your assets are going into the trust. Make sure that your assets are covered in the event of your death through a will and testament, and make sure you have somebody who can take care of your estate through power of attorney and trustees. All right. So I hope this helped you as you get further into your becoming a billionaire at some point in your life, and this should help you kind of give a good basis. Make sure you download these videos, keep them for future references. It's all good. I would say it's free, but it's not, because you paid for the class, of course. But if you ever need anything, let me know. I hope God richly blesses you, and we'll see you next time.